5 seconds to go. Start. Evidence of prosecution witnesses shows that more than 1 month before the alleged incident, the appellant accused and the prosecutrix exchanged frequent WhatsApp messages. Secondly, the appellant accused met the prosecutrix when she was traveling on the way to Hansi. The prosecutrix had informed the appellant about her visit to Hansi. Thirdly, while coming out of the hotel room, the prosecutrix did not raise any protest, did not make any hue and cry, or did not complain. She signed the hotel register while leaving the hotel with the appellant. Lastly, while entering the hotel, the appellant accused and the prosecutrix posed as husband and wife. All this has to be appreciated in light of the fact that we are dealing with a case of a well-educated victim who was married and a graduate. Her age at the time of the incident was about 28 years. It is true that the absence of injury on the person of the victim of the offense of rape is not always relevant, but in this case, the prosecutrix deposed that she sustained an injury on her hand as her bangles were broken. However, the medical officer PW9 deposed that there were no external marks of injury on any part of her body. We may also note here that on the way from Hansi, the prosecutrix travelled in the car of the appellant accused along with the appellant, and the guest house where they entered is at Bhiwani, which is close to her matrimonial house, as deposed by her in her cross-examination. According to the prosecutrix version, the appellant accused entered the Jindal guest house first and she was waiting in the car. If there was any compulsion made by the appellant accused, the prosecutrix could have got out of the car and walked up to her residence. However, she did not do that. There is one more critical aspect of the matter. PW15, the assistant sub-inspector of police who was investigating the offence, stated that she had called for the CD of what was recorded on the CCTV camera at Jindal guest house. She stated that she had seen the footage and had prepared a report on the basis of the footage. However, the prosecution has not produced the said CCTV footage. The prosecution had no reason to withhold such an important piece of evidence. The cumulative effect of the above discussion is that it is very unsafe to rely upon the testimony of the prosecutrix in this case. The submission made by the learned counsel appearing for the prosecutrix based on section 294 of the CRPC remains to be dealt with. Section 294 of the CRPC reads thus: where any document is filed before any court by the prosecution or the accused, the particulars of every such document shall be included in a list, and the prosecution or the accused, as the case may be, or the pleader for the prosecution or the accused, if any, shall be called upon to admit or deny the genuineness of each such document. Stop.